Hello, everyone. Welcome to the RAI Presidential Address. I hope you're all well, and we're just going to run through a few small housekeeping points. First of all, we've got two RAI staff here working kind of behind the scenes for the webinar. Well, that's myself, Amanda, and my colleague, Haneen, who's in the back and will be helping you with your chat. So the attendees to the webinar will see two buttons at the bottom, that is chat and Q&A. If you're using a laptop, those are at the bottom, and if you're using a phone, they'll be at the bottom, but iPads and tablets have them in the upper right-hand corner, and you may need to touch on your screen to get the controls to appear. The chat's for practical or technical questions, and the Q&A is for subject-related questions. So if you have a question for Professor Dame Sue Black, please ask it there. And in the chat box, you will see there's a drop-down menu, and you can decide to send your message to all panelists, which would be to my colleagues and myself, or to all panelists and attendees, and that will be seen by everyone. And please understand that the speaker will not be looking at the chat box, so probably won't be able to answer the questions there. So please ask them in the Q&A. Yeah, so once we get to the Q&A section of the webinar, please have your subject-related questions ready and put them in using the button that's labeled Q&A. You can also send a question anonymously, so if you'd like to do that, just check on the box to do it anonymously, and then close to the button and send your question. You'll be able to see other people's questions, so if you see a question that you would like to ask yourself, but it's already in there, just upvote it. And then we can see which questions are of the most interest to everyone. We may not be able to answer all questions during the Q&A, but if you have a particularly burning question, please send it to me at admin@therai.org.uk, and I will forward that on to the speaker. Please note that the contents of this event will be recorded and may be shared afterwards. So if you don't want your name mentioned when you ask your question, please do that anonymously. And I think that's all of my notes. So I will now hand over to our director, Dr. David Shankland.
Well, good evening, everyone, or good morning, wherever you are in the world. It's a great pleasure to see you here. I'm afraid our building, of course, is closed at the moment. The situation in Britain is still not, unfortunately, much better than in previous months. But I am pleased to see that Haneen, one of our colleagues, is actually running technical support from the Institute today. So at least we have some sense that she's in the building and that our building is all right. I would also like to say that if you're not fellows of the RAI already, student fellow or a full fellow, then please do feel free to join us. We are a community that receives no government grants. It never really has received any government grants. And therefore we are absolutely dependent on people globally becoming part of our institutes, contributing towards it, and at the same time helping us thrive as an intellectual community so that we can give something back to the discipline. And you will be most welcome to join us, and you can see how to do so from our website. It has been the happy tradition of the Institute since its very foundation almost 200 years ago to have a presidential address. And this evening we are delighted to welcome Professor Dame Sue Black for her second presidential address to the fellows and wider audience. And I will make a short introduction, and then we will have the lecture itself. And as Amanda has said, there will be time for questions afterwards. Our president, Professor Dame Sue Black, Pro-Vice-Chancellor for Engagement at the University of Lancaster, is one of the most distinguished anthropologists in the country. Sue began her career at St. Thomas's Hospital in London in 1987. She was appointed Professor of Anatomy and Forensic Anthropology at the University of Dundee in 2005, and then to her present role in 2018. With Louise Scheuer, she co-authored a number of textbooks on juvenile anatomy, texts that are now a cornerstone of the discipline. She has gone on to make a contribution in a multiplicity of ways, building up the program of forensic anthropology at Dundee to what is perhaps the largest in the country, and continues to direct substantial academic research projects. Professor Black is committed to forensic anthropology, not only as an academic, but also as a practitioner. She has accumulated a wealth of experience in casework, notably in high-profile cases in the UK, and also in the post-conflict environment in the aftermath of the Balkan Wars, where, in extremely arduous conditions, she sought to obtain closure on behalf of the living by helping to identify their lost relatives. For this wealth of work, Professor Black has received many police commendations, and in 2001 an OBE, which was in 2016 advanced to a DBE. Throughout this time, Sue has sought to establish and expand capacity in forensic anthropology nationally and internationally, and is the moving spirit behind the Forensic Anthropology Certification Programme, now approved by the Home Office, which provides a template for the discipline and its relationship with the courts going forward. Amidst this extraordinarily busy programme, Sue has found the time to write a moving memoir, All That Remains, A Life in Death, concerning her progression into the profession and the dilemmas and challenges that it can give rise to. A deserved winner of the Saltier Prize in 2018, I recommend it to all who would like to understand forensic anthropology better. We are now most privileged to welcome Professor Black for the second of her presidential addresses to the Royal Anthropological Institute.
David, you are so very kind. Thank you very much indeed. Ladies and gentlemen, welcome to my attic. It looks as if I'm maybe in a submarine or something, but that's what happens when you have a wood panelled space and it just absorbs all the light. Or it might be the fact that I'm in the north of Scotland where perhaps there isn't a lot of daylight left. So I'm aiming for the mysterious, ethereal look, and please don't criticise me too much if I don't quite manage it. It is a real pleasure to be president of the Royal Anthropological Institute. And it is very daunting to have to give these presidential addresses. And what I'm going to try to do now is share the screen, which I succeeded in doing earlier, but it doesn't always work that I will be capable of doing that. But I'm hoping that that will be clear for everybody. What I want to talk about this evening is the subject that I feel very, very passionate about, which is forensic anthropology. And it has been my lifeblood for the entirety of my career. And I've had a very privileged career. But where it does cause us some problems, and it shouldn't, because the entire rationale of what we do is in that first word, forensic, is the forensic part really pertains to the work that we are to do for the courts. But the courts are an alien place for scientists because the court has somebody else's rules, somebody else's game, and you are a player in a theatre that is being produced in that room at that time, and no two sets of the play will ever be the same. I think it's an area where, in many regards, those younger people who come into the subject, any forensic subject, think about the investigation and the excitement and the fact that it's going to be such an incredibly cool job. But what they forget about sometimes is that forensic bit, is that there is an expectation that you will be an expert witness into the courtroom. And the very first time that a scientist goes into a courtroom, then it is a really challenging environment. And I'm not sure that we prepare our young anthropologists for that as well as we should. There are two worlds. They overlap to some degree, but they are very, very separate, a little bit like oil and water. And what I'd like to try and do this evening is to bring those two worlds just a little bit closer together to show how the forensic scientist, or the scientist in general, has come to be in the position where they are allowed to give their evidence in court. Now, we have an unusual judicial system in our country because it isn't uniform right the way across our aisles. So we have a judicial system within England and Wales that has some echoes in what we see in Scotland and some echoes in what we see in Northern Ireland. And so some of what I'll say tonight will apply to one perhaps more than the other. And here is the first of those. So to understand, or apologize, to understand what a forensic anthropologist is going to face, then what they are going to have to do is to place themselves within that criminal justice system. And on that slide, you can see what the structure of the courts are in England and Wales. And they're different for Scotland and they're different for Northern Ireland. But there are commonalities in that system across the UK, and its prime purpose is for the delivery of justice to those who have committed crimes. And normally, for anyone who knows me, you know that I don't like to put a lot of text onto slides, but I'm also aware in this rather strange COVID digital world that sometimes people's audio breaks down. And so I've made sure that there's a lot of information that people can see, even if the audio isn't working particularly well. This whole system is made up a number of different parts, and those different parts have all got to work together if we're going to get a seamless progression right the way through the entire system. Part of the problem of our system, but also part of the benefit of our system, is the fact that it's separated into different areas, and different areas where a collective body have to try to come together to make sure that it does work. So what I mean by that is, for example, the Ministry of Justice, they're responsible for overseeing the different courts, the Legal Services Commission and the National Offender Management Services. The Home Office will oversee the police, and the Attorney General's Office oversees the Crown Prosecution Service, Serious Fraud and Revenue and Customs. And what I've blanked out on the right-hand side of that slide and just held, sort of put a transparency across is the employment appeals and tribunals and such things, because that's really not what we're talking about this evening. So this is the sort of court system in which the forensic anthropologists may find themselves. It's the true for England and Wales, but different throughout. So it's unlikely that the forensic anthropologists find themselves in a family court, but it is quite possible for the anthropologist to give, for the forensic anthropologist to give evidence for the court, although they might not appear in it. They may appear in county courts, but they are quite likely to appear in magistrates' courts. You are also very likely to find them in Crown courts, and then you're likely to find them in high courts. So that place for the expert witness is really quite well defined within the courtroom system. And of course, what we have above the High Court are the opportunities for appeal, when whatever it is that goes on within that court is perhaps judged by somebody not to have been ideal, and therefore it can move on to appeal. And the appeals might uphold what happens, or they might overturn it. Where does the expert witness sit in all of this? They're really quite a lonely little band of people. And I am not a historian, and that will become very obvious that I'm not a historian. But we do need to understand a little bit about how the legal system has developed to be able to see why we're now allowed to do the things that we do. I can't believe I'm taking us back to the reign of King Henry II from 1154 to 1189. But he was a really important sovereign because he started to undertake legal reform. And it was in his time that what we established was the basis for English common law. When King Henry came into his sovereignty, he was following on after King Stephen and Maud beforehand, and there had been tremendous upheaval in terms of land disputes, mainly associated with land that had been taken from the religious sectors, but also the transposition of land and ownings around the different nobility. And it was taking up so much of the sovereign's time that he decided that what he needed to do was to be able to farm it out. So effectively what he did was he introduced a system where he could subcontract what was happening in the legal system. He didn't want to hear all of these cases, and he wanted to give the authority to others to be able to do that. And within the local areas, what he did was he set up a jury of 12 local nobility. So whether they were knights or barons or whatever titles they may have, he gave them the authority to settle most of the land disputes, not the ones that were particularly important for the crown or particularly very important financially for the crown, but certainly those areas where he didn't want to spend his time. What he also did was he realized that with all the judges sitting in London, he actually needed to be able to send the judges out as well. And he dispatched these out to the capitals around the country as the traveling assizes. And so these individuals, these judges, had the authority in both the criminal and the civil matters to make a judgment on behalf of the crown. And that association with the crown in terms of the judges is particularly important. They started then to be able to introduce the juries into the petty assizes. And so you start to see from this point onward in the mid-1100s, the development of the core of what becomes the English common law system. We then had a little bit of a jump. Richard Lionheart wasn't in the country an awful lot, and he really wasn't terribly interested in what was happening in the UK. His sights were very much overseas. And the next sovereign that comes in to have a particular effect on the legal system was King John. And King John wasn't a particularly popular king. He really had to struggle to get himself to be accepted by the nobility as being the rightful sovereign. And he had a price to pay for that, because the sovereign had the ultimate control. And the free men, as they were, the nobility, decided that they wanted to remove some of that overarching power from the sovereign, because he was a weak king by this point. And he met with some of the rebel baron leaders at Runnymede near Windsor Castle on the 15th of June in 1215. He had been utterly undermined, and what they had set out to do was to force him into signing a great charter, a Magna Carta. And this Magna Carta was largely an assault on that singularity of royal authority. Now what the barons were saying was, we recognize the sovereign, but there are parts of the way in which the country needs to be governed that the free men, and they were men of the country, needed to have their say. They set up a council of 25 barons, and their sole job was to monitor the fact that John stuck to his word and he adhered to the charter. If he agreed to sign it, which he did, and he signed the Magna Carta at that date, what they agreed was they would stand the rebel army down and that London would surrender to the king. Now, John had to go through this in 1215, and you can see that his sovereignty ended in 1216. So he only had a year or so of living underneath these rules. And so in terms of the next sovereign, which was Henry III, he was placed with a Magna Carta. And he would have loved, I'm sure, to have been able to annul it, which he tried to do, and it was reissued again in 1216. So the Magna Carta was there to stay. It was reissued again in 1225 and again in 1297. And at 1297, under the reign of Edward I, it became confirmed as the first part of England's statute law. This is an incredibly important and rare document. There are only 4 of them that we know that survive in the UK of the original 1215 Charter. 2 are in the British Library, 1 in Lincoln Cathedral and 1 in Salisbury Cathedral. And they brought all 4 of them together in a celebration of the anniversary of the signing of the Magna Carta. They are priceless. They are a part of our heritage. But in 2007, there was one of the 1297 copies of the Magna Carta, which was the one brought in by Edward I, and that sold at Sotheby's for $21.3 million. There is a price on these artifacts. Of course, there is a price, but the real price of it is, in fact, priceless, because it forms the basis of so much of the legislation on which many, many aspects have been built. It has echoes in the US Bill of Rights. It has echoes in the Universal Declaration of Human Rights. And it also has echoes still in the European Convention of Human Rights. It's a document that we feel we almost speak in sort of hushed tones, that it has this mythical influence and transcending barriers, people who we believe had this great foresight. It really wasn't about great foresight. It was about ensuring that in the times of having a sovereign that was perhaps less than ideal in terms of managing the country, which of course King John was, then there were others that could have control of it. But it's become viewed as this kind of document of freedom, of democracy, of justice, and of rule of law. And history alleges that when we deny these, of course, what we do is we witness injustice and we deny justice. So it has become a symbolic document, as well as a very practical document, as well as a very, very valuable document. When you look at the Magna Carta itself, it is really just a continuous and unbroken text. And it wasn't until much later that it was separated out into 63 numbered clauses. And of those, there are probably only 3 of the original Magna Carta clauses that still remain in spirit in English law. And those are clauses 1, 39, and 40. And clause 1 is about freedom of the Church of England. But it's clauses 39 and 40 that have a relevance to this day in our legal system. Clause 39 said that no man shall be seized or imprisoned or stripped of his rights or possessions or outlawed or exiled or deprived of his standing in any way, nor will we proceed with force against him or send others to do so, except by the lawful judgment of his equals or by the law of the land. And that focus onto the judgment of his equals is really important, and the stipulation that it is by the law of the land. What it also states in clause 40 is, to no one will we sell, to no one deny or delay right or justice. And we've interpreted that over the centuries as being a right to justice, a human right to have justice, and a human right to have a fair trial by our peers. And our peers are what are represented in the juries that still remain within our courtroom. The jury originally were 12 free men, no women involved in this at all. And that 12 free men still resonates from those 12 knights that were the original jury sent out by the king to ensure that the land disputes were settled. In most of our common law jurisdictions, that jury is responsible for finding the facts of a case, whereas it's the judge who determines that the law is being upheld and what the sentence will be. These peers of the accused, they're responsible for listening to the dispute, evaluating the evidence that is presented. They then have to decide on the facts, and they have to make a decision in accordance with the rules of law and their instructions, and their instructions come from the judge. Typically, that jury will only convey a verdict of guilty or not guilty, not innocence, but guilt or not guilt, by what they have been able to adduce from the evidence that has been placed in front of them. It does not necessarily mean you are innocent. You are either guilty or not guilty found at trial. And the penalty then, if you are found guilty, is set by the judge. That differs in Scotland, because Scotland has a third verdict, and that third verdict is the not proven, or what in Scotland is often colloquially referred to as the bastard verdict. And that is about saying, we think there is evidence there, but we've not been able to prove it. And that then hangs over the individual who is accused. So what then happened in the 1700s is we started to have a bit of an adversarial revolution of what was happening in our courtrooms, because we started to see the introduction of an entirely different set of information coming into the courtroom, and that was the defense counsel. And that defense counsel meant that what we had achieved was an adversarial system. We were not in an inquisitorial system anymore, where you would not have this adversarial two sides to what is going on in the theatre of the courtroom. The defense lawyers or counsel were not allowed to directly address the jury. Their job was about gathering and adducing evidence, and they could examine and cross-examine the witnesses, but the jury was out of bounds to them. But by the time we get to the end of the 18th century, we found that in the courtrooms, the evidentiary battles have started to get quite heated, and we start to get the study of law into doctrines. And there were two particularly powerful doctrines that came to the fore at this time as a direct result of the adversarial revolution. And the first was the hearsay doctrine. And what that attempted to do was to limit testimony to information based solely on personal information. What it meant was you couldn't come into the court and say, I'm giving this evidence because the lady that I spoke to 3 weeks ago said that she heard it from somebody 3 weeks ago, that somebody else had said it 4 weeks ago, that he saw him do it. That is hearsay evidence. It means that the witness was not there to observe, to hear, or to see what actually happened. And so to be able to get that hearsay doctrine in and get it removed from the court meant that there was a clarity that was brought into the discussion that could be had around the evidence. And the other doctrine that came in was the opinion doctrine. And what that sought to do was to control the form in which witnesses communicated their information to the jury. So they weren't allowed to make an inference. They could only talk about what they saw or what they heard. If somebody asked, how do you think the victim felt? They were not allowed to give that evidence because it was an opinion, and the opinions were not allowed. But of course, what we are at this time is that we're in the century where we have a scientific revolution ongoing. We have a change in our country and in the world to such an extent of an industrial revolution where science was gaining much more of an authoritative control and an authoritative perspective in all aspects of our lives. It was inevitable that at some point or another, what was going to happen was that the scientist was going to end up in the courtroom, and that scientist is going to become the expert witness. So what's really important is that expert witness was not conceived as a deliberate judicial solution to any of the problems of expertise in our new adversarial courtroom. Instead, what the expert was, they remained the only source of information that the new system couldn't rationalize. It couldn't put it into its evolving doctrines because it wasn't hearsay, but it also wasn't opinion doctrine in the sense of the way opinion doctrine was being set out in the adversarial position. So the expert witness fundamentally became a freak of the new adversarial courtroom. And it was always going to take time to settle down until we could find how this new expert witness was going to be able to assist the court and how they were also going to be able to convey their information. What I want to take you to is the first case in the UK where we believe that an expert witness of science was brought into the courtroom. Back in 18th century Norfolk, there was a huge amount of experimentation in relation to the processes of farming. And the farming techniques that were being developed were so incredibly successful that the harbours were busier in the area of Norfolk than they had ever been. And in fact, they were probably shipping more grain around the world than any of the rest of England combined. So the harbours became a really important cog in the wheel of the economics of the country. There is a town in Norfolk which is called Wells, and it was called Wells next the sea, which is a wonderful term. And it had a harbour, but it was a tidal harbour. There was no river flowed through that harbour. And what it meant was that the harbour relied on the currents and the eddies of the tide coming in and scouring out the silt at the base of the harbour to keep the harbour channels clear so that the boats could gain access to the harbour to offload and to upload their grain that they were transporting. But what we started to see by the 1720s, that the harbour in Wells was beginning to clog, and the silt was beginning to really halt and impact on the ability of ships to get into harbour. And we'd got to a point where the ships were anchoring quite a considerable distance outside the harbour, and you had small skiffs going back and forward, taking the cargo in and out of the harbour. And that meant that it wasn't really particularly efficient or economically viable. So what happened was there had been some embankments that had been built around the Wells harbour, and the local landlords were being blamed for these embankments and saying that they were the fault of why why the harbour was starting to silt up. What the inhabitants then did was they tried to introduce some artificial sluices. That didn't happen. The harbour kept getting more and more into decay as the silt accumulated. And so what they did was they decided in the civil court that what they would do is they would take a legal action against the landlords. And so we have the Harbour Board of Commissioners taking the action against the local landlords, and the case is known as Folks versus Chad of 1782. This case is important, and it began in the Autumn Assizes in Norwich in 1781, the assizes being that ability for the judges and the judicial system to go out to the country rather than expect the cases to come to the city. The harbour authorities produced several witnesses, and the landlords very tactically produced just one expert witness, Robert Milne. And Robert Milne was a very well-known, very highly celebrated engineer and a fellow of the Royal Society. So he gave evidence in court. And he determined that the problem that Wells Harbour had was not caused by the embankment or anything about the building that had happened there, but the problem was that the silt was being driven down from the rivers that were north of the harbour, and that they were then being deposited along that north coast of Norfolk by strong tides that were coming in particularly from the Humber estuary. Well, the jury were completely convinced by this very articulate scientist, and the court found for the landlords. The locals, to say they were incensed would be an incredible understatement. The very fact that their local knowledge had been overruled by somebody who was viewed to them as being a foreigner from the city was too much for them to accept. And they moved for a new trial. And it was agreed that the new trial would occur because the reasonings of men of science, it was said, can only be answered by men of science. And what they felt was, in terms of overruling it in the appeal, was that they had not had the opportunity to bring their own man of science in to stand up against Robert Milne. So what happened was we had a new trial that was set a year later in the summer assizes in the summer of 1782. And what the commissioners for the harbour did was they secured 4 men of science, engineers, and one was even a vice president of the Society of Civil Engineers. And they got them to write a report to state that the reason the harbour was silting up was because of these embankments that had been built by the landlords. Folks, again, stuck with a recipe that had worked for him before, and he added only one expert to his testimony, and that was John Smeaton. And John Smeaton was also a fellow of the Royal Society, and he was considered to be the highest authority on harbours in the country, not specifically on Wells Harbour, but on harbours around the country. And Smeaton's testimony was that Robert Milne had been quite right, that the reason that the harbour was silting up was not about the embankments, it was about the silt that was being forced down from the rivers further north. The commissioners didn't learn, and they chose again to put their witnesses into the courtroom that were the local mariners and the local navigators. And when Fawkes was ready to call Smeaton, what they did was they objected. And they objected because they said that his was a matter of opinion, that Smeaton did not have any facts. What they were seeking to do was to restrict him from giving his opinion. They said that it was speculative. And if it was to be an expert opinion, then it had to have calculations, and it had to have empirical observations, and it had to be specifically about the harbour in question. What happened was that Smeaton was not allowed to give evidence, and the jury on this occasion found for the commissioners. So the first jury had found for the landlords, the second jury had found for the commissioners, and the whole reason about this case was based on the fact of these expert witnesses that each side was trying to bring in to the courtroom. Well, Fawkes' lawyers, no surprises, appealed again, and they appealed that their expert, John Smeaton, had been improperly silenced, and they required a third trial. It's almost as if you keep going to trial until somebody gets the answer they want. But of course, the trouble is they both had already the answer they wanted. What happened next is what's really important in relation to the expert witness. And that is that Lord Mansfield decided that he would uphold and support the appeal. And he found that Smeaton was a credible witness. And so he granted that third trial. And in doing that, almost irrespective of what the outcome of the third trial was, in doing that, he said that Smeaton's theory was very proper evidence. And so he gave and set the groundwork for a scientific expert to be brought into the court to be able to give their opinion based on their expertise. And that had not happened before. And this formed the foundation of the rules that govern the expert evidence and the role that a scientist can play in the courtroom. And when you understand where that comes from, you can see how it fits very neatly into a sort of progression and reform of a legal system. Just to show you what we were talking about, the star that you can see, the blue star on the image on the left, is where Wells next to the sea is occurring, and the arrow is in fact the effluent that's coming out from all of the rivers that come together and come out through the harbour, through the Humber. You can understand why Smeaton and Milne might have said that actually the problem wasn't those small embankments that were built around the harbour, but in fact that there were much greater forces that were in play here. And when you look at a current satellite view, and the top images on the right and the left there are aligned, you can see the amount of silt that lies outside the Wells next to the sea harbour. So Smeaton and Milne were correct. They'd been able to take that bigger picture, and they'd been able to bring the bigger picture into the courtroom. What the local navigators were saying was that once the embankment had been built, that's when they started to see the silt developing, but the two were not necessarily connected. And that's why the expert evidence is so important. So what is the role of that expert witness? And that expert witness is alone in the courtroom, the only person who is able to give evidence of opinion. They can be asked, what do they think? And that places them in a very privileged position, but an extremely important position, because they're there to help the jury, who are the triers of fact, to come to a conclusion. It's their conclusion. They're there to give a level of expertise that it cannot be expected that the jury would have themselves. So they are bringing a knowledge into the courtroom. If the jury had enough knowledge, because it was a simple everyday premise, the expert witness would not be required. But the expert witness also needs to know where their limitations lie in terms of their own expertise, and that becomes really important. The role of the expert witness is not to persuade the jury. The role of the expert witness is to provide evidence and opinion that allows the jury to make the decision. We are not there as advocates. We are not there to persuade. We are not there on the side of the prosecution or the defense. We are there to assist the court and the jury. And we know that that expert witness these days must follow a developed methodology which is explicable and is open to a possible challenge, because we have an adversarial system. And that's why it's so important that the expert witness is impartial. The modern expert witness is governed by a number of legislative acts, but also codes that are expected of them. The most important is the Criminal Procedure Rules of 2015 in England and Wales, and the Criminal Procedure Scotland Act of 1995. Apologies that I don't have on there for Northern Ireland. And those criminal procedure rules are rules by which the court must operate to ensure that it is effective, efficient, and proper and fitting to its duty. What we also have are some codes of practice that have been produced by the Forensic Science Regulator. And the regulator is a Home Office post whose position is to ensure that standards and quality are upheld in our scientific forensic expert witnesses. But then what we also have is, because there are so many different types of forensic, each of those expert disciplines also have their own code of conduct that they are expected to uphold. What's interesting about the criminal procedure rules is that they are there for the court. They're not there for the expert. And although we read them, they are not there to help us in our role in the courtroom. They are there to ensure that the legal process is upheld. And the part of the criminal procedure rules that are most important are obviously for the expert witness going to be those in relation to Part 19, because Part 19 of the Criminal Procedure Rules 2015 govern what the court expects of an expert witness. And in our reports to the court, we have to state that we are abiding by those, that we have read those, and we blooming well have to do that and not just pay lip service to it. So what the expert witness has are booklets that are given out that try to help us, that try to ensure that when we are going into court, we know what the court expects of us. We know what our limitations must be within the remit of that court. And in our reports, we also have to state that we have read this guidance booklet. And it's the way of showing to the court that we've taken our role and our responsibility as an expert witness very seriously, because we know that what we have is a unique position within the courtroom where we, above all others, are allowed to give an opinion. And it's a privileged position that we need to ensure that we fully understand what is expected of us. Now, please don't worry, I'm not going to go through all the criminal procedure rules. Everybody would be asleep within the first 2 minutes. But there are parts of it that become particularly important. And this part one just shows you that what this is about it's instructing the court. If you want to bring an expert witness in, here's what you have to do. These CPR, these rules are not for us as the scientists, they're for the courtroom. But there are some really important things that we have to understand, because we know we're going to be questioned on them in terms of a process when we get into court. Our duty is to the court. Our duty is not to who secured us, whether that is the Crown in terms of the prosecution or it is the defence. As experts, we must be objective and we must be unbiased, and we must understand the limitations not only of our own expertise, but the limitations of our subject as well. And we mustn't stray outside those. We have to stay within an area where we have a legitimate expertise. We have to comply with the court, because if we don't, then we run the risk of being in serious trouble ourselves. So we need to make sure that we know what it is that we're there to do. We have to inform the court if there's any significant failure, either by an expert or another, And we have to try and take steps to change the direction of that. We have to give an expert report, so we have to write it down. And then we have to often go into court to give live evidence based on that report. What we can't do is then add extra information unless we provide an addendum written report to the court in that time. So no new evidence can ever be given by the expert witness as they stand in court. It must always have been written and submitted to the court beforehand in a written format. So we also have to draw the court's attention to any question that arises outside our expertise. And even though it may make us look foolish, we have to say that is not within my area of expertise. Now, you can't say that to everything in the hope that nobody's ever going to ask you a question you have to answer, because then that really takes a huge focus on your credibility as an expert witness. And if you change your mind, you have to tell the court. And changing your mind is really important. It might be that new evidence has come in. It might be that new research has been undertaken. And the stance that you took before is not the stance you take now. That again has to be written down and has to go to the court, because there should be no surprises in your evidence in the courtroom. When you look at the codes of conduct, and the codes of conduct as they're set out by the forensic science regulator, are codes of conduct that we should recognize and should uphold without having to be told. But you do need to set these out. And there are a set of overarching codes of practice and conduct for all forensic experts who go into the courtroom. And they are things, and I just selected a few of them there, that would surprise nobody. Recognizing that our overriding duty is to the court and to administering justice, to be honest, to have integrity, objectivity, and impartiality. We are not experts for hire. We are not there to promote either the Crown or the defence's stance. We are there to help the jury understand the evidence. We have to act in as an expert evidence within the limits of our own confidence and competence. So that if we're not competent in a particular area, we have to say it. And we have to make sure that we maintain that competence, because if we don't show evidence of staying up to speed with the entirety of our discipline and the research that goes on and the casework that goes on associated with it, then we can't be effective as an expert witness. So it is a huge, absolutely huge area to try and keep on top of at all times. What we also have are codes of practice that are set out for disciplines. And we did this for forensic anthropology. And we did it in partnership with the Royal Anthropological Institute, with the Forensic Science Regulator, and with the British Association for Forensic Anthropology. So we set up a collective set of codes of practice that were approved by the regulator that we as a discipline must uphold. And because the Royal Anthropological Institute is a part of that codes of practice, the fact that we set them up, then there is a professional body recognition for our discipline within the Royal Anthropological Institute. And the things that are in the code of practice, and you can read them on the website if you wish, please do. It talks about our duties and our responsibilities. It talks about our competency. It talks about what's expected of us as a general forensic practitioner, what would be expected of us at the scene, what we would do in terms of recording information, what we would do if we're in the mortuary, what equipment we might use, how we validate it. It talks about documentation, and it talks about records and how we write our reports and how those reports must have peer reviews. It talks about disclosure, and disclosure is a particularly important aspect when you are the expert witness working for the Crown, because the Crown must have full and complete disclosure to the defence. And so there is nothing that can be hidden away. It's about openness, it's about transparency. And we have that obligation to the court. And this is drummed into us repeatedly, time after time. When you look at the criminal procedure rules, and 19.4 in particular, it talks about the expert's qualifications, it talks about their relevant experience, and it talks about their accreditation. And in the codes of practice, we talk about what we expect an expert forensic anthropologist to have in terms of qualifications in the UK. We also talk about relevant experience and what that experience looks like. And there are always going to be individuals who have more experience and those who are looking to gain that experience. And as a community, what we say is it's really important that what we have is a mentoring system that allows those who are less experienced to learn from those who are more experienced, because without that, you will never have a build in the level of discipline and in the level of practitioners that we want to be able to achieve. But it was in this point of accreditation where the Royal Anthropological Institute became particularly important for the discipline of forensic anthropology in the UK and its standing within the courtroom. What we did was we developed a professional certification and continuous professional development program. And they require recertification on a regular basis. For some aspects, it's 3 years, for others, it's 5 years. But what the certified forensic anthropologist must do within the scheme is adhere to the requirements to maintain their competency and to gain their certification with the RAI. And we've informed our police forces, we've informed our courts that there is a certification system for our discipline and that it should be questioned. So in all of this, the forensic science regulator has approved the way in which the discipline of forensic anthropology, the professional body of the RAI, and the society associated with the British Association of Forensic Anthropology have worked together to make sure that when forensic anthropology goes into the courtroom, that it's fit for purpose and that it knows what its purpose is and that it's unlikely to lead to a miscarriage of justice. Of course, they happen, but at the end of the day, all you can do is ensure that you put enough safeguards in to make sure that it doesn't. We have 40 certified and soon to be chartered, because the RAI is soon to be a chartered institute, 40 certified RAI practitioners in the UK. 8 of those are at the level 1, and a level 1 is as senior as you can go. These are practitioners who have not only the experience, but they have the continued professional development to be leaders in ensuring that the discipline continues to move forward. They have almost all, in fact, I think they have all, without exception, courtroom experience, because it is such an alien environment to go into courtroom that it's important that what we have for our police are those classified groups of experts that they know have been bloodied in court already. They've had that maiden voyage into court. There has been bloodletting and they've got through the adversarial system. The second level of forensic anthropologists, we have 5 of those in the UK, and they are at a level where they have really sound practical and theoretical knowledge, but they've not yet been into the courtroom. And I cannot tell you how terrifying it is for an expert witness to go from that transition of thinking, I'll never need to go to court, to that citation arriving in your box and you know that you are going to give evidence in court. We want to ensure that those level 2 anthropologists manage to get up into the level 1 anthropology by serving the court, but also making sure we have served them as well in terms of their development. And the forensic anthropologists 3, not surprising, that's the largest number, 27 of them. These are individuals who have evidence that they've got some experience in the field, they've got some knowledge in the field, but they may not have been involved yet in a forensic case. And there is a real process for them to be able to move up from 3 to 2 to 1, and ensuring that each of those that are in a category above are in the position to be able to mentor those who are in a category below. And that's a really, really healthy system. It's a really healthy system because what we want to avoid is the celebrity scientist. And the celebrity scientist is a real problem for the courtroom. And there was none better than Sir Bernard Spilsbury, He was one of the most celebrated of forensic scientists. He became known as the people's pathologist and dubbed the real world Sherlock Holmes. He was masterful in the court. He was incredibly erudite. He had a real flair about him. The jury loved him, and they almost said, if we can get Spilsbury into court, you know, the case is won anyway, because nobody will be able to stand up against him. That sounds great for the television. It might sound great for the Crown as well, but it doesn't serve justice. And although there is no doubt when you look at the early cases of Spilsbury, he really was an incredibly rigorous and impressive scientist. But I think over time he fell victim to the fact that he was a celebrity, and he began to believe his own rhetoric and his own infallibility. There is no place for an ego in the courtroom, because if you have one, you will lose it very, very quickly. So in conclusion, what I've done, as I hope I've been able to give you an understanding of where that expert witness lies, where the forensic anthropologist as an expert witness lies, but I have to also say that it is still an alien environment for that expert witness, that scientist, that forensic anthropologist in the courtroom. And there are things that we need to know. There are tricks that we need to learn. And what we know is that on average, we know how lawyers are trained. And lawyers will come after you on 3 quite distinct levels. Quite rightly, what they will do is they will come after you about your evidence and your credibility. So we need to be sure that when you go into court, that your evidence is sound and that you are credible. So you have the right qualifications, you have the right accreditation. What you won't do is speculate on areas about which you know nothing. And being able to say that is not my area of expertise is the most important piece of advice that we can give to any forensic anthropologist coming up through the grades. When a defense lawyer or a Crown lawyer, depending upon which side is against which they believe your case is supporting, then what they will do if they cannot pick holes in your evidence or your credentials is they will start to look at your processes and your procedures. What did you do? Why did you add that? Did you write that in your notes? Why didn't you write that in your notes? If you didn't write that note in your notes, you know that you're expected to do that as a witness because that's what's written in the Crown Procedure Rules. Why didn't you do it? Are you not a credible witness? And you can see just how quickly that can descend into a position where suddenly the court is being told you're no longer a credible witness, when what you may have done is simply forgotten to sign a little bit on a part of your notes. So your note-taking, your processes and your procedures have to be absolutely buttoned down because they're going to be examined as well. And if there are no holes to be found in your evidence and your professional credibility, and there are no holes to be picked in your procedures and your processes, what will happen in the court is they will come after you personally. And they will go away, and trust me, I've had it. They will troll on Facebook and on social media, and they will find things that you have done in your past. And I've had a colleague who in court was asked, in a lecture that you gave to your students 10 years ago, and here is the slide, you said this. This is not what your testimony is saying today. Have you changed your opinion? Please do not think for a moment that anything that you have done in your past will remain a secret and not become considered by some lawyers to be relevant to the court when they are trying to do the best for their side of the equation. It is a challenging place, the courtroom. It is an incredibly rewarding and it is a privileged role to be an expert witness and to know that it goes back into the 1700s that we are allowed to give our opinion. But in giving our opinion, it must be an opinion that at the end of the day is based on evidence and is within our areas of expertise. Ladies and gentlemen, thank you very much indeed for your attention, and I will stop sharing the screen now. David.
Well, thank you. That was absolutely marvelous. You really held us all enthralled, I'm sure, wherever we are in the world, and quite against your fears. I'm sure even if it's nighttime, I'm sure that they were equally equally, I'm glued to the screen. Questions are beginning to come in, but I think one that many of us will have in mind is the relationship between forensic anthropology and anthropology more widely. And there is indeed one question asking you to clarify that. But in addition, I wonder whether you can expand just a little bit, something that's always puzzled me, to do whether expert witnesses are all under the same rubric when they go into court, whether they're as social anthropologists or whether they're as forensic anthropologists. And I'll give you a specific example. Was that although I've not done expert witness cases for a little while, about a decade ago, in the last ones I had, the solicitors were beginning to say to me, we do not want to hear any comment from you whatsoever about the plausibility of the evidence. What we want to hear is whether or not it is congruent with the society with which you work. Yeah. So I would say to them, look, these are forged. And they say, we do not want you to say that. We want you to say whether what's written in them is plausible given your general knowledge. That seems to me extraordinary, because my expertise, as much as it would be to be able to work out whether or not this particular account was plausible or not the generalized one. And I'd be very, very grateful whether you could comment how that kind of thing fits into the framework that you outlined to us this evening.
And there, I think, is the real sort of difference between what happens between your kind of anthropology and my kind of anthropology. And what I mean by that is when we go into court, we have a specific case that we have been involved in, usually, if we're presenting the report. So it is our evidence that we're giving. And so therefore we are able to give our opinion on where our evidence sits within the bigger picture. Now, we're generally not asked about plausibility, I do have to say, and that would be one that would really catch me in the courtroom. But I wonder if it is to do with the social side of anthropology, which a courtroom, incorrectly, from my views, might not see as a science, but as an arts-based theoretical concept. I don't know is the truth, but I just wonder if it might have something to do with that. Whereas from the forensic anthropologist perspective, we will be questioned on the methodology we've used, the statistics of it, the probability of it, things that have a really well-defined mathematical and evidential base. We will then be asked occasionally, what is your opinion on? But it is unlikely to be on the kinds of things that Smeaton did, which was talking about the plausibility of a harbour somewhere that he'd never visited being able to be silted up by something coming out, 200 miles north. I wonder if it's civil and criminal court difference, and I also wonder if it's the different sides of anthropology. But I suspect there are people much better qualified to be able to answer your question than I. And if there was any lawyers in the room, then hopefully they're the ones who should be able to answer that. But as I'm seeing a lawyer in the next couple of days, I shall ask them the question, David, and come back to you.
We will see, because there are many, of course, different kinds of anthropologists going before the courts. But the specific question then here is does forensic anthropology fall under the category of the social sciences, as anthropology often does? Or if not, where does it lie as an academic subject?
So generally, it was born predominantly from biological anthropology. So when you look at the early forensic anthropologists, they were by and large either coming from the anatomy community or they were coming from the bioanthropology community. And so it is that measurement basis in many ways. It is the looking at the physical aspects of biological anthropology.
Right, thank you. And going back to the earlier part of your talk, Robert McDowell, good evening, Robert, would like to ask, does the adversarial system of English law tend to undermine the integrity of the expert witness?
In some cases I've been in, I'd say yes, and in other cases I would say no. And the answer is, of course, it depends. There is no right and there is no wrong. The adversarial system, what it does do is it allows the courtroom to really challenge the evidence. And that I think is important, but the evidence can be almost subsumed sometimes in games. And what the English system has done particularly well is to bring together this opportunity, first of all, of expert witnesses coming together. So you will get the Crown witnesses and the defence witnesses coming together. And what they will do is they will agree on the evidence in which they agree. And that will then be accepted by the court. What you then have is a situation where the areas of the evidence where they don't agree, that is what is focused on in court. And that evidence needs to be challenged from both sides. You go into court hoping you're going to come out an expert, and sometimes you come out an idiot. It really does just depend on the way in which the trial goes, in some ways, the questions that are asked. Because of course you're not allowed to give testimony. What you are allowed to do is to answer the questions that are asked. And there are times when you really want them to ask you a specific question, and if they don't do it, you can't give that answer. But an inquisitorial system, which is the opposite of the adversarial, has its own problems because it doesn't have that same level of challenge. And as a result, I think there becomes at times almost more of a complacency in terms of acceptance of the information because it's always been accepted. Whereas the challenge actually does keep you very much on your toes. And sometimes that's for good, but sometimes it actually, you know, it falls short, and we have less than ideal outcomes.
Yes, I see. Well, there's a question now that mentions something called Dobert in the USA from Dr. Rosen. She says, how well versed are the courts in forensic anthropological methodology and the potential limitations? What standards must forensic anthropology as a discipline fulfill to be considered suitably admissible in the UK?
Yeah, so the Daubert and Fry, there were two of them, but the Daubert in particular principle was about standards that were set that said you need to meet these particular thresholds, and if you don't, we're not letting the evidence into court. The UK system hasn't adopted that as such, and it is the gatekeeper role of the judge to decide what evidence is admissible and what is not. So if you come forward as an expert in forensic wallpapering, then what may happen is that the prosecution says, I want this forensic wallpaperer to give evidence. And the defense may object and say, I'm sorry, but I don't believe there's any credibility in forensic wallpapering. What will happen is the judge will then remove the jury from the room, and they will have a voir dire, where the judge will decide whether there is sufficient scientific evidence underpinning forensic wallpapering to allow that evidence to be heard. And so that's a really important decision that a judge makes as a gatekeeper, to decide what comes into court and what does not come into court. But sometimes things get into court and there isn't a solid scientific underpinning necessarily behind them. And that needs to get played out in the courtroom sometimes. But we've tried to overcome it recently by developing something that are called judicial primers. And what the judicial primers do in the UK is they are written by experts. They are then edited by another group of experts. They are now edited again by a group of judges. And we have a series of these primers that allow the judges and the courts to understand what degree of credibility evidence should be given. So for example, the first two that were written, and these are judicial primers that come out of the Royal Society and the Royal Society of Edinburgh as the national academies. And the first one was on DNA. And as we all know, there is a tremendous amount of evidence upholding the strength of DNA as expert testimony. But there are areas where there are problems, and that's particularly in where we have mixed profiles, for example. And so these judicial primers are live documents that allow the court to know at what stage a particular science is at. The second one that we wrote was on gait, which is the way we walk. Now, there's a huge amount of evidence in science on gait and how we analyze gait and how we correct gait in the clinical literature. The actual process of forensic gait analysis has significant scientific problems underpinning it. And so that's brought to the attention of the judges. Now, they may decide not to let gait analysis in, or they might, but knowing that it has a limited evidential impact on the case. And as we talk, the Royal Society of Edinburgh, and the Royal Anthropological Institute are coming together to produce a judicial primer on forensic anthropology. And that's been written by, we have a group of writers who have produced their first draft. So I've seen it. It hasn't gone yet to the editors, and it will go to them within the next few weeks. And again, it's about informing the court about what is to be expected of a particular type of science that will come before them. So it's a slightly different way of doing it. But yes, they absolutely do have to know what is the error of their measurements or the errors of their assumptions, yes.
Thank you. And there are two linked questions here, so let's take them together. So, and thank you for your questions. Tuba Siddiqui asks, to what extent would a question regarding an expert's background need to be answered by the expert in court? How should the expert tackle such a question? So in other words, if the opposing side says, you know, you're obviously an agent of a foreign country, how do you respond? And the linked question to that is from Sigourney Abraham, and says, if your credibility is questioned in this way in one court case, does it not affect your reputation or credibility in the future?
Absolutely.
And if so, how will it affect you being called in as an expert witness?
So, and I have been one of these. I am a perfect walking example of one of these, where a court case in which I was involved, the verdict was for the Crown, and it went to appeal. And in going to appeal, the judge decided to overrule the findings of the court. And it was a murder trial, and it should never have been a murder trial, because I don't believe that the mother did in fact commit murder, but it was a murder trial. And the way in which the evidence was recorded fairly damning on myself and on a colleague. And we felt unfairly, I have to say. That was supported by the Lord President, it was supported by the Lord Advocate, it was supported by the First Minister. But at that point, what I was looking at was the fact that a single case would actually have stopped my forensic career at that point. And I could not have gone forward if there had been anything negative assigned to my name. Now, what happened was something that was unprecedented, and I don't think has happened since, was that the senior judiciary in Scotland issued a press apology to both myself and my colleague for the way in which it had been handled. And that is about as close as the courts can get to actually saying, we handled this badly and we got it wrong. It was probably the most harrowing time of my personal career. And it shows every single expert that your reputation hangs every single time you go into court, and nobody is immune from it. So when I gave evidence in court just last year, the defense lawyer had no evidence that he could question on me. He had no evidence he could question me on in terms of processes and procedures. So he went back to this case. And he said, in this case, we believe that there is an adverse record against you. So what you have to do is you produce the records that say, no, there isn't. And you play it out in court every single time. But the very fact that it has been overruled now so many times has not yet necessarily crept into the remit of every defense lawyer who thinks I can bring a scalp down. And so that's what I mean about the court being incredibly alien. If you make one mistake, which may not even be your own fault for the mistake, you may just have to stop practicing. And I was very lucky that I didn't have to, and that the support that I got from the senior judiciary actually made it possible for me to continue and for that to be recorded as such. But it is an alien environment. And if you are worried about your reputation, you don't become an expert witness in court. You don't become a forensic scientist, because you can only expect that you will be challenged on every single thing that you do. I have seen a court case come to an end because an expert witness did not record in her notes how many hours she spent looking down a microscope. It can be things as ridiculous as that. I don't happen to think those serve justice, but those are the vagaries of the courtroom.
Yeah, me. It sounds like a very high risk business.
It is, and it's not to be entered into lightly.
So what do you do? Let me just give me an example. A case that one's in has some evidence, say, from France. Yeah. And one of the lawyers stands up, either before the case or during it, and says, it's quite clear to me that at some point you had a grant from the French government, and therefore you are, by implication, your first loyalty is the French state, not to this court. How can you reply to such a gross insult? What do you do?
This sounds very personal, David.
Oh, no. But also it's relevant to the question that we have here.
Right, okay.
How does one respond if one gets such a ridiculous, insulting accusation against one's character as an expert?
Well, first of all, accepting a grant for a research grant from a legitimate body is not an indication that you have a particular affiliation to that body. It's why it's important that when you accept research money, that it is research money that you're prepared to stand up in court and justify. And most of the research funds that we have, certainly in the UK, are through credible sources. And when they come from overseas, it is the same. So they could question me in court that, I have a €2.5 million grant from the European Commission. Maybe in court they're going to ask me whether I should have accepted that when the UK will no longer be in Europe. I don't know. That could be a question that will come to me in the next courtroom. And you just have to say, I do not believe this is relevant to my evidence. My evidence is about this particular fact. It is not relevant where my grant has come from, because that grant was from an authentic funding body. If you take your funding from drug runners or from a drug cartel, then you get what you deserve. And that's why it's important that you choose in all seriousness where your money comes from and where your papers are published, because that can also be something that they will catch you out. And they will go away and they will read papers from different things. I mean, in the particular case in question, the defense counsel said to me, and we were talking about parts of a bone where growth gets halted sometimes when the individual is under periods of stress. And they produced a paper to me that said, look, we have a research, papers that are published in journals are credible, aren't they? We all know the papers that manage to get through the review system and get published that are not credible. So your only answer to that is many are, but some are not, because the system is flawed. And the paper in question was, it was rabbits that had been strapped into a straitjacket, and they had been x-rayed. And some of the rabbits had been fed and some of them had been starved, apparently. And it showed that these lines occurred on all of them. So this was nothing to do with nutrition. The very fact that all the darned rabbits were stressed, that this was a really flawed piece of research. So you need to understand the research that's good and to be able to critique the research that is bad, even though it still gets into the journals. And it's why for our students, we say it's really important to be able to critique papers and to be able to make a decision on whether the research that's in it is based on something of substance or complete and utter farcical nonsense, as it is on rare occasions.
Oh, we have a few questions perhaps from people who are starting out here, and they don't give their name, but they say, how and where should starting forensic anthropologists gain and practice their expert witness testimonies? It sounds like a very difficult thing to train for by yourself.
Yes, it is. And I wouldn't advise it. So for many students who go through courses in our universities, part of that course is about how to give expert evidence, how to write the report, and how to stand up in court. I think that's sufficient when you're at an FA3 level. But if you're heading into an FA2 level, you need much more intensive training. And there are commercial courses that you can go on that will allow you to do that. But the thing that's free is you can walk into the public space in any courtroom in the country and just listen and just see who gives good evidence, who gives bad evidence, what happens in the cross-examination, what happens in the evidence in principle. So being able to just witness it, and everyone is able to go and do that. That's why our courts are open. They are public places. You can learn it there. So, you know, if you're in a course, it should be in your course. If it's not, I would advise you speak to your course organizers and get it in there. If it's going to become your career, you might want to go and take a professional course, but anybody can go and sit and listen.
That's very useful. And there's a related one here, particularly as the situation looks like it's going to carry on for some time. And we have a question here. What advice would you give for gaining further hands-on experience of skeletal remains in the UK amidst lockdown restrictions if you are not currently based in an osteoarchaeology department? Yeah,
so it's really difficult times for our discipline as much as it is for anybody else. Our courses, in terms of social distancing, are challenging because forensic anthropology is a practical discipline. Although you can do a lot of theory, you really need to get your hands on the material. And that's challenging for universities to be able to provide, I suspect, at this time. I'm no longer teaching forensic anthropology, but I can imagine myself being back in my department and how difficult that is in the space. Of course, crimes go on, so that there are still crimes where experts are called out. And whilst our FA1s are out there assisting with the crime scenes, they will take FA2s with them or FA3s with them. So those who are already on the accreditation process have got a much greater chance of getting actual, genuine forensic hands-on experience, which is why I would advocate anybody who is looking at a qualification in biological anthropology, in osteoarchaeology, in forensic anthropology, you are likely through the coursework that you've done and through the experiences you've had to actually qualify for our FA3s. So go in there and apply, become a fellow of the RAI and look at that FA3 qualification. Because once you're in, then we're able to mentor you and help you move forward.
Yes, and that's relevant to the next question. And broadly speaking, we all should perhaps ask whether there's a huge amount of work for forensic anthropology. I mean, does every single court case have one? But this particular question also is, how does a forensic anthropologist get assigned to an individual case?
Okay, so there's no easy answer to any of those. I'm sorry to say. So in relation to, if I deal with the second part first of all, which is how do you get so the second, remind me again, David. My mind was thinking faster than my mouth was talking.
No, I'm so sorry.
I've been on the go today since 7 o'clock this morning.
The second part is, how does one actually get allocated a specific case?
So, exactly.
And the first one is there lots of work around in forensic anthropology?
Thank you. So I knew I was on the wrong track. I was thinking, no, it isn't about expertise, it's about allocation. So that depends. And it depends who you might be working for. So for example, it may well be that the police uncover human remains, in which case, if they are an enlightened police force or a police force that has a contract with a forensic provider, then they may well request that the forensic anthropologist goes to the scene. They will then request the forensic anthropologist is present in the mortuary when the investigation is being undertaken. So the police can do it, but also the forensic science providers, if you're working with a commercial company, they may well be attached to different police forces, and so therefore they will know that those services are available to them. Sometimes it is a case of the procurator fiscal or the coroner equivalent will want a forensic anthropologist to become involved, and they will often contact the experts directly. So what they will do is they'll come to the RAI site, they will look at where the contact information is for our certified experts, they'll decide what sort of a level of expertise they need, and they will contact us directly. Of course, the defense will also be looking for a forensic expert. So they will have seen through disclosure that the Crown have got an expert, they will want to put their expert up against. And so the Crown will go looking for, where do I find an expert forensic anthropologist? And again, they will know that the certification process comes through the RAI. they will go to the webpage of the RAI and they will find the expert there. Now, unfortunately, sometimes what they don't know is that some of our colleagues work for the same company. And so therefore we will have to say, sorry, I actually can't help you in this case in defense because my company is working for the Crown in this case. And so we have an open disclosure of what we can and can't take on. And how much work is there? Again, you know, it depends. Sometimes you will go for 12 months and there's nothing for you to do. And suddenly there's 3 cases coming a week. And there is no way of predicting the unpredictable. And the unpredictable is because this is based on crime and it's based on the crime being uncovered. So sometimes we can be very, very busy. Sometimes it can feel as if we're going through a real famine. But one of the areas of expertise that I've developed and really probably play more of a part in these days than any is in identification of perpetrators, usually of child sexual abuse, from images. And I can honestly say that that is a workflow that has no sign of decreasing whatsoever. That is something that is on the increase. And as we become more and more well known for being able to look at this part, then there's more and more work coming. And what we need are experts that can come into this field as well.
Well, that's very relevant to a question that Natalia Schönmorgen asks when she says, is forensic anthropology closed to someone whose qualifications are in social or cultural anthropology? Is there any way that she can bridge the gap?
The forensic anthropology that we do is the biological anthropology. And so what I would say is your anthropology background is incredibly valuable and very relevant, but you do need to understand and study the biological anthropology before you can get into the forensic anthropology. Because the stunning irony, David, is what you do when you go into court is also forensic anthropology, because it's the application of anthropology into the courtroom. And so we've just suddenly got this total misnomer that forensic anthropology is just about biological anthropology. Of course, it can be about any aspect of anthropology that goes into the courtroom. Forensic comes from the Latin forensis, meaning pertaining to the forum, and the forum were the courts of Rome. So forensic anthropology is really just anthropology for the courtroom. We just happen to have hijacked it into the biological anthropology.
Well, they're clearly subjects for future talks here. I think we just have time to sneak in just a couple very quick ones. And Marissa Acosta would like to ask what advice you would have if somebody from outside the UK would like to become more involved in forensic cases internationally from their point of view, for example, in the UK.
So that's a really interesting and a really important question. In terms of our certification process within the RAI and the one that's been accepted by the forensic science regulator, it requires us to have, certainly to get up to FA1 level, experience within the UK. There is nothing that stops you going into the FA3 category that shows you have the relevant qualification and the relevant experience. But it does require you to be in the UK if we're going to be able to mentor you as cases come through. So it's very difficult for a mentor who's assigned in the UK to somebody who is living and resident overseas. You can see why that wouldn't work. Our certified anthropologists will go and work overseas. Of course they will. And we have other organizations around the world that certify. So in Europe, there's the Forensic Anthropology Society of Europe. And the certification process there is very similar to the RAI one. So being able to get that certification is what's really important. So if you then came into the UK and you could prove that you have the qualifications, you have the experience, and you have certified, not necessarily in the UK, but possibly elsewhere with an accredited system, then you may in fact be able to give evidence in court within the UK. I can't see any reason why you wouldn't.
Well, there we are. Well, we're just about out of time now. But there is a fascinating one here from Andrea Derry. She says, have you come across Folks in Chad, 1782? The legal case, also interesting for the debate about the nexus of local and scientific knowledge. Perhaps we can close on that one.
No, not specifically, but I do know what you mean. Yes.
Well, there we are. There we are. So, well, thank you for an absolutely fascinating tour de force, one that's taken us across history, gives us a better knowledge of our own system, a better knowledge of what forensic anthropologists do, and an equally fascinating discussion session. So we are greatly in your debt. And all we can say is, well, we can't offer you a celebratory dinner as we normally would be able to, but it'll just have to be sometime in the future. But thank you so much.
You're welcome. Thank you to everybody. Thank you and good night.
Good night.